S14A 1874, William Cottrell Sr. et al. Versus Atlanta Development Authority, DBA Invest Atlanta et al. John Woodham for appellants, Matt Calvert and Tom Kervin for appellees.
May proceed when ready.
Good morning, Your Honors, and Mr. Chief Justice Thompson. May it please the Court, my name is John Woodham, and I'm co-counsel for the appellants in this matter, along with my colleague, Judge Thelma Wyatt Moore, seated at counsel's table. As the Court is aware, the appellants in this matter, Reverend William L. Cottrell Sr., Miss Mamie Lee Moore, Miss Tracy Y. Bates, Bishop John H. Lewis III, and Mr. Joe Henry Beasley, who are all in the courtroom here today, are each citizens of the state of Georgia and residents of the city of Atlanta who have intervened as a matter of right and become parties to the subject bond validation proceeding for purposes of challenging the proposed taxpayer public subsidy to the tune of approximately $1 billion over some 30 years to fund a portion of the construction and long-term maintenance costs for a new stadium for the Atlanta Falcons, which stadium is generally referred to interchangeably in this proceeding as the successor facility to the Georgia Dome and the new stadium project, or NSP. We are asking this court to reverse the 88-page validation order and final judgment entered by the trial court on May 8, 2014, which I might add is an 88-page verbatim order prepared by counsel for the appellees and entered by the trial court without changing a single word or even any aspect of punctuation. In any event, my hope is to quickly address three primary issues before the court today, relying on briefs for other matters and hopefully saving some meaningful time for rebuttal. Now, the public dollars at issue in this case are derived from the City of Atlanta Hotel Motel Tax Levy, currently levied pursuant to 48-1351A5. The city currently levies a 7% hotel motel tax levy pursuant to that statute, of which 39.3% of that 7% is required to fund what is referred to in the statute as a, quote, multi-purpose domed stadium facility owned by the state or a state authority. And that current tax levy is used to service bonds issued by the World Congress Center back in the early 90s for the original construction of the Georgia Dome. And so we commonly refer to that existing facility as the Georgia Dome, that multi-purpose dome stadium facility where the Atlanta Falcons NFL team currently plays their home games. Now, the core dispute in this litigation is the result of a 2010 amendment to 48-1351A5 set forth in Section 1 of House Bill 903, that's at Georgia Law 210, page 809, which was signed by the governor on June 3rd, 2010, which added a new subparagraph B, and which purports to now allow a jurisdiction already levying a tax under Section A5 to extend that tax levy for another 30 years out to December 31st, 2050 to fund a so-called successor facility to the Georgia Dome, which will be the new home stadium for the Atlanta Falcons, provided that some very, very specific and narrow conditions are first satisfied. Now, I've placed on the Elmo for the court's convenience, a copy of the new subparagraph B that was enacted. When I say new, it's as of 2010. And I've highlighted some specific language, which I will touch on shortly. As the court is aware, we've made a direct constitutional attack on subparagraph B as an unconstitutional special law in violation of Article 3, Section 6, Paragraph 4A of the 1983 Constitution of the State of Georgia, often referred to as the Uniformity Clause. But before I discuss the unconstitutional aspect of subparagraph B, I think it's critical to first address City of Atlanta Resolution 13R0615, a certified copy of which is in the record at page 261, which resolution was ostensibly adopted by the Atlanta City Council on March 18, 2013, and signed by the mayor on March 21, 2013, for purposes of extending the city's existing hotel motel tax out to December 23rd, December 31st, 2050, pursuant to the purported authority set forth in the new subparagraph B as enacted as part of HB 903. Now, I hope the court can see. The beginning of the highlighted language there is what I'm going to read briefly. Subparagraph B states in part, a tax levied under this paragraph may be extended by resolution of the levying county or municipality and continue to be collected through December 31st, 2050, if a state authority certifies, et cetera, et cetera. And we'll get into those narrow conditions. But the first issue to look at is the condition precedent that's embedded into this statute. The World Congress Center Authority did not issue the required certification until February 12, 2014, a full 11 months after the city's March 2013 resolution. So the city simply did not have the statutory power in March 2013 to enact the city's purported tax extension resolution. Now, the statutory language, particularly the use of the word if, is plain and clear that the certification is a condition precedent to the ability of the city to exercise the power to enact the city's tax extension resolution. And we have cited ample authority in our brief for that proposition in terms of the common understanding of the meaning of the word if as a condition precedent in the legal context. But nonetheless, to the extent anyone wants to argue there is any degree of ambiguity in the plain language of the statute as to the meaning of the word if, we need simply to look at the applicable language from the title clause of House Bill 903, which I'll flip to. And I've highlighted, which states, to provide for extension for purposes of funding a successor facility upon certification of certain conditions by a state authority. Now, while a title clause or caption is not part of the act under Georgia law, it may be resorted to in aid of statutory construction in the event of any alleged ambiguity. And I'll cite Bentley v. State Board of Medical Examiners of Georgia, 152 Georgia 836. It's a 1922 case, but this is still good law. It's not part of the law, but it can be resorted to if somebody wants to argue there's an ambiguity.
Mr. Woodham, what is your best authority that it's unconstitutional violations because it's a special law?
That would be the Lassiter case.
The Lassiter case, right?
Because the Lassiter case is so clear that it dealt with a single plant. It was so narrow in its application to a single plant. This subparagraph B relates only to a single project in the state of Georgia, being the successor facility to the Georgia Dome. It's limited in subject matter, territorial application, and in time. So Lassiter is the best case for it being a special law. Now, special law is not per se unconstitutional, but a special law cannot amend a general law, and this is what this new subparagraph B did. It's a special law that was grafted onto an existing general law, and a special law cannot amend a general law. And we've cited ample authority for that proposition. The Stewart v. Anderson case, 140 Georgia 31, a 1913 case. We can even go back to Mathis v. Jones, 84 Georgia 804, a 1890 case authored by Chief Justice Bleckley. And there are cases throughout the years that repeat the same principle that a special law may not amend a general law. So that really is the core issue of why this special law is unconstitutional.
Is it clear in the record that there are no other projects anywhere in the state that would fit within the parameters of paragraph B?
Yes, Justice Melton, and we have the affidavit of Stephen Stansel, which is in the record at 1795. Now, he is the state property officer serving as executive director of the Georgia Building Authority and State Properties Commission and director of the Georgia Financing and Investment Commission. We have his affidavit, and I will place down a portion of it. And the important part to look at is paragraph 5, where he says, as of June 3rd, 2010, which is the effective date of subparagraph B, the Georgia Dome was the only multi-purpose dome stadium facility in Georgia owned by a state authority or any public authority of the state of Georgia. At that time, the Georgia...
But paragraph B doesn't relate only to multipurpose dome stadium facilities. It talks about particular types of taxes that any jurisdiction could have imposed for specific purposes, and then you get to extend it. And so my question is, or do we know that there is only one such tax anywhere in the state?
Yes, we know that because the portion that is relevant for purposes of subparagraph B is the portion that requires 39.3%. If you go down a few lines from where I've highlighted, the subparagraph B has a couple different components of how certain portions of the taxes must be expended, but 39.3% of the 7% must be expended towards a successor facility to an existing multi-purpose dome stadium facility. So it's very specific. The original statute allowed the 39.3% of the 7%. It had a sunset provision of December 31st, 2020.
Your argument is that's the only dome facility out there.
Yes, and that's what the state property officer is telling us. It's the only one in existence in the state of Georgia. Therefore, it can be the only one that has a successor facility to it.
Was the other, when they built the dome originally, did it also violate the special law provision in your view?
No, because the special law provision didn't exist at that time. Subparagraph B was enacted in 2010. So our contention is that the pre-existing version of A5, 2010 amendment amended A5 to add a subparagraph A1 and 2 and a new B. Now, A1 and 2 basically was what the old statute was. We contend that was a perfectly constitutional general law at the time it was enacted because when it was enacted, it was potentially operational throughout the state.
Now, you said special laws don't per se violate the Constitution. Can you address the circumstances where they do or don't, and specifically, Matthews versus Macon Water Authority?
Well, the core issue which the appellees don't address is a special law cannot amend a general law, and that's just well-settled authority. And so that's clear on its face. Now, if we want, now a secondary argument, which is we can discuss, is the preemption rule principles of City of Atlanta v. Hutchins, which this court confirmed is still the law in this state in the 1998 decision of Franklin County v. Fielddale Farms.
They cite Matthews versus Macon Water Authority for the notion that if you have a special law that actually makes some sense, you can go ahead and do it.
But they do cite that. Matthews and McAllister are not, they talk about you can accept certain things or persons from a law, but it doesn't make it not a general law because it's still operational statewide. And that's what the difference is here. Paragraph B does not have statewide operation. It has operation only in Fulton County, City of Atlanta. So those cases they've cited that they call exceptions are exceptions to what's in a general law, but it doesn't violate, it's still a general law because it has statewide operation. If that answers your question, Your Honor.
If that's the answer.
Going back to your question about the timing of the state authority certification, what about, I think it's Berry, the case that says that can be cured, and effectively if there's no challenge or no bonds issued until both the resolution is enacted and the state authority is certified, that there's no harm.
Well, the Berry case, Your Honor, there was a specific statute in that case, 3680 something F. I don't have it off the top of my head. The court relied on a statute that said as long, and it was a failure of that authority to register with the Department of Community Affairs prior to issuing bond indebtedness. Well, that authority registered with the Department of Community Affairs prior to the issuance of the bonds, and the statute actually contained the cure itself. So that's how it's the Berry case is very distinguishable from what we have here. The only way to cure this, I mean, we have we have the city exercising, purporting to exercise power in 2013, which it didn't have, because the trigger event for the delegation from the General Assembly was the certification from the World Congress Center. It didn't happen until February 12, 2014. So, and this case would be controlled by cases such as H.G. Brown and the City of Baldwin case, which it's similar to a charter. If you exercise a power at a time you have no authority to exercise that power, it is a void act. Now, as the court is aware, you can simply reenact. They could have reenacted the March 2013 resolution, but they simply haven't done it.
But they could do that to cure it.
They could do that. They could have done that in last February during the bond validation proceeding. And they've, I stubbornly or perplexing to me have simply failed to reenact that statute. And as the court is aware, and particularly with the case that was issued just October 20th, authored by Justice Blackwell, the Newton County case, it's long been the law in this state and reaffirmed 2 weeks ago that the only way to cure a void act is to reenact it. And that's all they have to do, but they haven't done that. And, you know, until they do that, it remains void, obviously, until they reenact it. They could go and try and reenact it next week. I don't know why they haven't taken the action to reenact. But as it stands, the city resolution that was purportedly adopted in March 2013 did not extend the hotel motel tax because it was void. Therefore, there is no security for the proposed bonds, meaning that the proposed bonds are unlawful, and the validation order can and should be reversed on that issue alone without even having to reach the constitutional issue. Very quickly, I have a little time left. Very quickly, the revenue bonds at issue are not, the funds to be paid from the city to the ADA are not derived from the project, nor do they arise out of or relate to the ownership or operation of the project, which is the requirement in the revenue bond law. And therefore, these are unlawful revenue bonds. These aren't revenue bonds recognized under Georgia law. So,
was that raised below? Was that argument raised below?
yes, Your Honor.
Okay, I thought there was some representation that may not.
This is one that was definitely raised below.
Okay.
If there are not any more questions, I'll
I do have
reserve.
one other question.
Okay.
Going back to special law, the Constitution, I think, says that you can have a special law. Well, you can't have a special law only in any case for which provision has been made by an existing general law. So would you have a violation of the special law prohibition where there, in areas such as this where there is no general law already providing for?
Well, the pre-existing law that was amended covered generally the same subject matter. And if you look to the city of Atlanta v. Hudgens case, 193 Georgia 618, it doesn't require that the general law be exhaustive. It simply touches on it. If it gets into the area of it, the special law cannot be enacted that addresses. And the pre-existing general law concerned a multi-use dome stadium facility where 39.3% of 7% was going to be to fund it. And, you know, the court has reaffirmed that. The principles of City Atlanta v. Hudgens, Justice Benham did in his dissent in Glamo v. Cousino, 287 Georgia 7.
Don't reaffirm anything.
Well, I understand that.
Can I just ask, the existing law, though, cut off all of these taxes as of 2020, right?
The pre-amendment did.
Yeah. So any tax for a facility that was going to take longer, that would have a very large capital investment, wasn't accounted for unless you extend the tax, which is something, the time period of the tax is not covered by the pre-existing general law.
The time period is not, you're correct, but when you look at the City of Atlanta v. Hudgens, the language is so broad in terms of the language in that decision that it's close, it's the general law existing, the old general law is not exhaustive of the subject matter. So that's what we would rely on the City of Atlanta v. Hudgens view of the preemption.
But if we actually took that law at its face value of touching on, then, for example, our decision in Glamo, to which Justice Benham dissented, would have come out the other way.
Well, again, the primary issue that we're relying on, Justice Anamias, is that we have what is clearly a special law that purports to amend a general law. And we need not even get into the analysis of their implied preemption. That is so squarely the case here that that's our primary focus. I'll reserve the balance if I might. Thank you.
May it please the court, Matt Calvert for the City of Atlanta and Invest Atlanta. It is undisputed in this case that the new Congress Center Authority Stadium, currently under construction as a successor to the Georgia Dome, will promote tourism, stimulate the economy, and provide other benefits for Atlanta and the state. The trial court in this case properly rejected the numerous challenges to the use of City of Atlanta hotel motel taxes to partially fund the stadium, and this court should not disturb that decision. I will address the issue of the general law, special law, as well as the scope of the revenue bond law and whether it permits this financing. And Mr. Kervin, on behalf of the Congress Center Authority, will address the issue of the city's resolution and the timing of the resolution relative to the adoption of the tax certification by the Congress Center Authority. The Uniformity Clause provides quite simply that laws of a general nature shall apply generally and uniformly throughout the state, and that no special law shall be enacted for which provision has been made by general law. A party challenging the constitutionality of a statute, as this court well knows, has a high burden. They have to prove unconstitutionality in the sense that it's clear and palpable, and if there is any reasonable interpretation this court can make of a statute that's consistent with constitutionality, the statute must be upheld. In this case, the trial court rejected the constitutional challenge to the hotel motels tax on two grounds. The first ground is that the trial court found that the original levy provision, that's 481351A5, and the extended levy provision, which is Section 5B, are each permissible exceptions to the general hotel motel tax statute, which enables local governments to enact a 3% hotel motel tax statute. That statute is intended to promote tourism, conventions, and trade shows. The original tax levy allowed a local jurisdiction to enact a 7% hotel motel tax, 37.3% of which would go to fund a multi-purpose dome stadium. And in 2010, the legislature allowed in Section 5B that the exception apply to permit funding of a successor facility and to permit the tax to be extended past 2020. Now, the test for the constitutionality of an exception is whether the exception is reasonable and not arbitrary. And there are two important decisions of this court that are on point. The first is the McAllister case. In the McAllister case, this court upheld a general law exception that accepted blood manufacturers from the doctrine of strict liability and tort, and it permitted that exception to ensure the availability of blood supplies. The other important case is the Matthews case, which Justice Melton asked appellant's counsel about, and it took two questions before an answer was provided. The Matthews case did not involve a general law exception to a general law, as appellant's counsel suggested. In the Matthews case, this court upheld a local law enacted by the legislature as part of the charter of the city of Macon. And that local law provided an exception to a single municipal water authority to the doctrine of vicarious liability. And the rationale, what made that reasonable, was that that exception facilitated more economical water and sewer rates for a single municipality. That was deemed to be a permissible exception to a general law of vicarious liability. We submit to this court that if it was reasonable of the legislature to accept blood manufacturers from the doctrine of strict liability, and it was reasonable of the legislature to accept a single municipal water authority from the doctrine of vicarious liability, both doctrines intended to protect injured citizens of this state, then surely it was reasonable of the legislature to enact the original levy provision to permit funding of a multi-purpose dome stadium, and it was reasonable of the legislature in 2010 to permit local governments that had enacted such a provision to extend that tax in order to pay for a successor stadium after 2020. The second ground for upholding the hotel-motel tax against constitutional challenge is based on the proposition that even if the original levy provision is deemed to be a general law, the special levy provision deals with a matter that's not covered by or provided for by the general law, and therefore there's no conflict with the uniformity clause. Now, the appellants contend that because the original levy provision deals with a multipurpose dome stadium, that somehow preempts the field, that there's no ability to legislate on some other matter that has anything to do with the stadium. And we submit that is simply not correct. The amended levy provision, the extended levy provision, provides for the extension of the tax past 2020. As Justice Namias pointed out, that tax would have expired in 2020. The original levy provision did not deal with the same subject matter in terms of time or scope as did the extended levy provision. Tax could be extended past 2020. Tax could be extended to fund a multipurpose or successor facility to a multipurpose dome stadium. Now, the appellants are harping on the notion that you cannot amend a general law with a special law, but we submit they're dodging the question. The issue is, does the special law deal with a matter that's not provided for in the general law? And if it doesn't, whether you call it amendment or something else, that's not what's controlling. The question is, does it provide for what is covered by the general law? And we submit that the extended levy provision does not provide for that which is covered by the general law.
So, as I understand your argument, you almost concede it as a special law, but you're arguing more that it falls with one of the exceptions to make it constitutional.
Under the first ground that the trial court ruled on, that is that it was a permissible exception to the general 3% hotel-motel tax statute, that does not require engaging the issue whether it's a special law. It's simply an exception as permitted. Under the second prong, or the second ground, you're correct, Justice Melton, if you treat the original levy provision as a general law, then the extended levy provision is a permissible special law in that it does not deal with a matter covered by the original levy provision. Now, it was interesting that appellant's counsel said the Lassiter case is, in response to your question, Justice Hines, their best authority. The Lassiter case did indeed deal with a special law. What the appellants don't want to concede is that in Lassiter, this court upheld that special law. And in the Lassiter case, the legislature allowed for accelerated depreciation of a single oil-to-coal conversion project at a single public utility at a single location in the state. And that was deemed permissible. That was deemed an acceptable special law in that it did not deal with a matter covered by a general law, and it was deemed to be reasonable by this court to permit accelerated depreciation at that single plant to ensure more economical rates for the ratepayers. We submit that same logic would apply here. The extended levy provision does not deal with the same subject matter, that is tax past 2020 or a successor stadium, and it was certainly reasonable of the legislature in enacting the extended levy provision for purposes of promoting tourism. And as I said at the outset, there's no question that's what this stadium will do. It will promote tourism and the economy. It was reasonable, we submit, for the legislature to do that. The other issue I'd like to address is the issue in respect to the revenue bond law. The revenue bond law, we submit, does not require that a development authority own or operate a project, or in this case, that Invest Atlanta own or operate the new stadium project, in order that tax proceeds paid by Atlanta to Invest Atlanta under the tax proceeds agreement, that is the hotel-motel tax funding agreement, in order for that agreement to be a proper intergovernmental agreement. That argument we submit, Justice Melton, is untimely. It was not raised until after the pretrial order was entered, until after the validation hearing. It was injected in the case in a post-hearing brief, and the trial court said in its final order, page 28, that new objections raised after the pretrial order were entered were untimely. Now, the appellant's counsel wants to say it's a question of semantics, whether it was a new argument or a new objection, but the fact is it was not raised by the time of the trial. Moreover, we submit that it is meritless.
The way he couched the argument to us today more related to whether you can use tax monies to pay down those bonds. Is that the same argument?
Well, as I understood the argument, it's hinged on the proposition that the Development Authority cannot characterize as revenues taxes paid by the city pursuant to the intergovernmental agreement unless the Development Authority owns or operates the project. And he says
I didn't hear the emphasis on whether they own or operate the project. I saw that in the briefs, but I didn't hear that in the argument presented to us.
Well, my assumption was they're relying on it because it's the only argument set forth in the brief for this point.
Well, all right. I do have some questions about whether you can rely on tax monies for revenue bonds, period.
Your Honor, in the Clayton County case, this court made it clear that you can.
Exclusively?
Not necessarily exclusively, but in that case, taxes paid by the county to the authority pursuant to an intergovernmental agreement to repay bonds was deemed permissible.
But that was just part of the RICS. There was still some revenue, bona fide revenue that would not be discounted because there was some tax money used to pay off the bonds.
Well, in the Avery case, there were payments made by that was the case last fall, there were payments made by the aviation company that were to pay the bonds, and the intergovernmental agreement between the county and the authority provided for tax revenues also to pay for the bonds. So yes, tax revenues paid by a municipality or a local government to retire bonds under an intergovernmental agreement are permitted to be revenues derived from the project. And that's, in fact, what is done in this case based on Clayton County. There's no question that the hotel-motel tax funding agreement between Atlanta and Invest Atlanta is a proper intergovernmental agreement. Invest Atlanta is authorized to engage in projects including sports facilities. In this case, the services provided by Invest Atlanta under that agreement will include providing financing for the cost, partially, of the new stadium project. Invest Atlanta will provide services to the City of Atlanta in the form of reporting and monitoring responsibilities to the city. The city, in consideration for the pledge of hotel-motel tax revenues, will enjoy the benefits of the tourism and economic development generated by the stadium. Now, the statutory language that the appellants are relying on is at 368261(3). The definition of revenue, it says revenue includes all revenues, income, earnings arising out of or in connection with the operation or ownership of the undertaking. Nowhere does this language require that the undertaking be owned or operated by the Development Authority. Here, hotel-motel tax revenues paid to Invest Atlanta will arise in connection with the ownership and operation of the stadium because they will retire the bonds that fund the stadium. And the connection between the revenues paid under an intergovernmental agreement to retire bonds to fund a project is the same. It's no different whether the Development Authority issuing the bonds owns this facility or simply financing facility. And it's clear under the Development Authority's law that development authorities do have the ability to acquire and construct projects, but they likewise have the power, the express power, to extend credit or issue revenue bonds to fund the project. And that's exactly what's happened here. There's no requirement of ownership. At this point, if there are no further questions, I would defer to Mr. Kervin on the other issue.
And since you don't have much time, can you initially address the question of the timing where the statute seems to say that the city's resolution can pass a resolution levying the tax if there's been a certification?
Yes, Justice Namias, I'm prepared to devote most of my argument to that. The appellees submit that the trial court properly concluded that the proper reading of the statute, the most straightforward reading of the extended levy statute, the grammatically correct reading of the language of the statute, and frankly, the commonsensical reading of the statute is that the certification is a condition that must ultimately be provided and satisfied, but it's not a condition precedent to the passage of the bond resolution. the better reading of the statute, the correct reading of the statute, and frankly, the commonsensical one, leads to the conclusions that so long as the certification is provided before the tax is extended and collected, then the statute's certified. That's exactly what was done here. We submit that the city's authorizing resolution perfectly tracked what was contemplated in the extended levy provision. The city passed an authorizing resolution saying that, and keep in mind, this was done at a time when the current hotel motel tax is still in effect. So we're not in the period of the extended levy yet, and indeed we won't be in the period of the extended levy until after this deal closes, if it closes. And so what the city did was passed a resolution that says we will extend the current hotel motel tax pursuant to the extended levy. We'll extend it through no later than 2050 on condition that a state authority provides us the certification that's required by the statute.
Is that what the resolution, does the resolution expressly condition it that way?
Yes, Justice Namias, it does, and it is in the record. That is undisputed. It is a condition built into the extension of the hotel motel tax that the statutory certification has to be provided. We think the city went about it exactly the right way there. The way this deal is structured, there is no way that this hotel motel tax can be extended beyond its current expiration date unless this deal closes. And so when the city acted as it did, it acted consistently with the statute, and it structured its resolution in such a way that the hotel motel tax never would be extended had a state authority like the Congress Center Authority not provided the certification that includes